When the Law Society of Upper Canada decided to sponsor a one-day workshop on basic problems in evidence, the response was somewhat larger than was anticipated, and the program was therefore subsequently repeated. The workshops took the form of a lecture followed by a panel discussion in each of the morning and afternoon sessions. The panel discussions were, however, a little out of the ordinary. They consisted of a number of short TV scenarios, each of them followed by a panel discussion examining the various evidentiary problems that arose. In the second workshop, the panels were switched around a little so as to give some variety in opposing views. Both sessions were recorded on videotape, and these programs are an edited version of the discussions of the evidentiary problems arising from the simulated courtroom scenarios. I do not think you will find many clear-cut answers to these fairly common problems. What you will find are discussions of some basic but extremely important principles from which solutions are suggested. This program is designed primarily for the legal profession, though we hope that others will be interested and will perhaps gain some insight into the workings of this aspect of the legal system and the way in which the law tries to reconcile conflicting interests. For the lawyers in particular, citations and references will be given for cases and materials mentioned should they wish to make a note of them. There were in total 4 panels, of which 2 each discussed separately half of the fact situations. On the first day, chairing panel number 1 was the Honourable Mr. Justice Edson Haines of the Supreme Court of Ontario. With him appeared Mr. William Poole, QC, practicing in London, Ontario, and a member of the Ontario Law Reform Commission, and Professor Hugh Silverman, QC, a practitioner of many years' standing, and now Professor of Law at the University of Windsor. Chairing panel number 2 was the Honourable Mr. Justice Thomas Zuber of the Supreme Court of Ontario, and with him were Mr. Clay Powell, QC, Counsel in the Ministry of the Attorney General of Ontario, and Professor Desmond Morton, QC, who is both a practitioner and a law professor at the University of Toronto. Mr. Justice Zuber also chaired the first panel on the second day's program, and appearing with him on that occasion were Mr. Justice Frank Weatherston of the Supreme Court of Ontario, and again Professor Hugh Silverman. Mr. Justice Haines chaired the last panel, again with Mr. Clay Powell and Professor Morton as the panelists. As a result of the editing, panel discussions do not always appear in the order in which they were presented. There seems to be a popular conception that what someone says to a witness is not admissible because it is hearsay, but if something is said by a third person in the presence of a party, that is admissible because it is not hearsay. Neither proposition, of course, is correct. Whether what someone has said to a witness is or is not hearsay depends on the use to which the statement is being put. Where a third party makes a statement to a party to an action, that may be admissible against that party only where he adopts it as true. He may adopt it expressly or by conduct, or in some rare situations by his silence. But in this last case, which the panel is going on to discuss, silence can only amount to an adoption if the reasonable man would be expected to react differently.
Claim for damages arising out of an automobile accident. Plaintiff's counsel is examining a police officer.
And I understand that you took the plaintiff and the defendant to your patrol car?
Yes, I did. They both sat in the back seat. I sat in the front.
And while the 3 of you were there, did another person come over to the car?
Yes.
And did he say something to you about the accident?
Yes, he did.
And was that in the hearing of both the plaintiff and the defendant?
Yes, it was.
What did he say?
Lord, I object to that question being asked, and I object to the answer that it asks for. That's clearly a hearsay point, and my friend, being an experienced counsel, knows exactly what he's doing, and I'm surprised he would ask a question like that.
My Lord, I submit that the statement, although it may be hearsay, was heard both by the plaintiff and the defendant. My friend will have the chance to cross-examine if he wishes, and I would submit that in this hearing it is admissible.
Well, if that's the case, my Lord, then perhaps your Lordship should hear argument in the absence of the jury.
I agree, my Lord.
Now, in order to stimulate the panel, may I throw out these ideas for your discussion? First of all, is there any difference as to whether this is a civil case or a criminal case? And I raise the criminal issue because of the right of the accused to remain silent. Assume that he has been advised by the policeman that he doesn't have to say anything. Assume again that he hasn't been advised by the policeman, he's just sitting there. And then, if you will, consider that he's charged with some serious crime. And the circumstances are such that it may be expected that he should reply. The Christie case, as you talked about, Mr. Poole. And again, we've got the criminal case in our present law and the right to remain silent all mixed up in this. But let's go a bit further and assume that the person who comes up is an accomplice. Probably he was the fellow who was driving the car, the other car, and so on. Now, those are some of the things I think we should talk about for a little while. Would you like to tee off, Professor Silverman?
Well, I think you're right. We should make a distinction between the civil and criminal aspect, and certainly the Christie case and the Eden case mentioned by Dr. Mewett are most germane here. The question of whether something was said in the presence of the accused in the criminal area, and whether or not he's then normally expected to reply. In the Eden case, that of course was the important facet or feature of it, whereas in Christie, silence may be possibly interpreted according to one's conduct or statement or anything, demeanor, as acceptance or adoption of the statement. That's the first thing. Now, in the civil area, we don't know here what the policeman is doing exactly at this particular stage. We don't know whether he is contemplating, it doesn't tell us whether he's contemplating laying a criminal charge or not laying a criminal charge. So that's a very important facet, whether he's gathering the information for the under the Highway Traffic Act or not.
I think we should assume it as the first case, that he's really conducting his investigation at this moment.
At that point. I think the important thing is it relevant? Will it be something that will illuminate the particular situation? Now, the fact that he's in the back, that this happened while some people are sitting in the back of the seat of a police cruiser may have some bearing on the situation, whether it's civil or criminal, in that particular sense.
Well, just imagine the situation where he says, pointing to the defendant, I saw him run that red light. That's very important, isn't it?
I would say it is.
Right. Now, under those circumstances, the defendant says nothing.
Well, at that point, then we have to look at what the Ontario Court of Appeal said in the Eden case, which does seem to be, as Dr. Mewett said, a more sensible approach than the Christie or the Norton case that preceded it. Would he normally be expected to make a denial with respect to that statement? And one has to consider the particular situation. If somebody did say, I saw him run the red light, and of course that was the cause of the accident, one would normally expect him to say, no, I didn't run the red light.
In other words, you're saying the circumstances are such that the court should admit it because on the constellation of all those circumstances, a normal person would have made a reply.
Would have made a reply.
Or denial, whatever it might be.
On the basis of Eden.
Right. What do you think of that, Poole?
Well, Mr. Chairman, I think that in the criminal law it is not admissible. I don't think you're required to make any statement under our present laws as a citizen, and I think you can remain silent if you want. And furthermore, in this particular case, the policeman said that this interview took place in the back of a police cruiser, which means that he's not free to go, and in effect he's under arrest at that time.
Oh, no. Surely not. You haven't the authority for that proposition, have you?
Well, my authority is if he tried to get away, he'd find out.
No,
But in the civil, on the civil aspect, I don't think it's admissible as hearsay if its purpose is to establish the truth of it. But I think it is admissible in a civil suit to show that a statement was made, providing the parties might reasonably expected to make some observation or explanation. And as a matter of fact, there is a case in the British Columbia Court of Appeal in 1973, Attorney General of British Columbia versus Thomas, in which, or Thomas versus the Attorney General of British Columbia, in which the Attorney General in a civil case appealed against 4 people who were in the car and they couldn't determine who was the driver. And one of them made a statement and then was missing, and they allowed that in. This is pretty much the same as this case, and if I was the judge, I would admit it in a civil matter, not as the truth, but to show that the statement was made. And I'd get around the hearsay rule, I think, that way.
No, but what, you show the statement is made, but it's referable to what object?
It's referable. You see, one of the rules in my judgment on this matter is, have the parties been deprived of any aspect of cross-examination? Both parties were here. So you could ask them in the witness stand, did you hear the witness make the statement? What'd you think about that? So you're not deprived of your right of cross-examination, which is one of the things that's always held up on the hearsay rule to keep evidence out. I think the trend is to let it in. Both parties were there. What harm would be done?
All right, turn it into a criminal case with the right to remain silent. Now what do?
Keep it out.
Well, with respect, is not the whole concept before us that by his silence, he adopts the statement or accusation made by the witness?
Under certain circumstances, which is a matter, I suppose, for the trial judge, but I don't think that you can go this far, Mr. Chairman, because he remains silent ipso facto, he's adopting it.
Well,
there must be something more.
Let's take some illustrations. They're not yet in the police car. The policeman is standing there. He doesn't know who the drivers are. Up comes the witness and says to the policeman, that man was driving the car that ran through the red light. And the man says nothing. Is that admissible? Criminally or civilly? No arrest, nothing like that. Now, would you admit that?
I think in a criminal case you could get it in. I don't think it should be admissible, because I don't think there's any onus on the accused to make any statement at all. My clients, the ones that aren't in Kingston, never say anything.
Oh, that's because you've instructed them in that regard, haven't you?
Well, that's one reason. The other reason is they don't get a chance because I talk too much.
Well, but you agree then if he's outside the car and the policeman is standing there, he's merely a bystander, that evidence then becomes admissible if the circumstances are such that the trial judge can say that by his silence he adopted it.
Yes, I think then you can get it in on that basis.
Now you move him from the roadside into the police car, and the policeman is making inquiries as to what happened. It's raining, it's cold, and all the rest of it, and the witness comes up. Is the fact that he's inside the car while the policeman is still inquiring make any difference?
Oh, I think so.
What is the difference that you see?
Well, he's under arrest and he doesn't need to make a statement. And if he doesn't make a statement, or if he doesn't adopt it, which is the same thing, it shouldn't be held against him.
No, hold that situation for a moment. I didn't say he was under arrest. I said he took him into the car to investigate.
Well, they weren't in there for a tea party.
All right. But he's just in the car. He may have taken him to a house nearby.
He's restrained them.
All right. Anything like he invites them into a house nearby, and whereupon they report what happened. Now, does that fact that the policeman has taken them there change the situation? The policeman hasn't made up his mind now to charge anybody he doesn't know. but he believes these two people are the participants.
I think once the policeman restrains them, it's a whole different situation. I don't think it matters really how he restrains them, whether he takes them into the house by invitation or gives them a kick and gets them in there.
In other words, you're saying that once a policeman invites someone into the house, the man is under arrest, even though the policeman hasn't made up his mind to do so. But for the purpose of this rule, he's under arrest, and anything he says in the presence of that policeman is to a person in authority.
That's right.
And that the admission by silence becomes a statement to a person in authority. What do you think of that?
Well,
And you have to have a voir dire.
I think the fact of having the policeman there is very important. Certainly, we all know from the Tepper case where this fellow was charged with arson and his house was burning down, the witness said, say, why are you running away from this fire? This is your building or something, and it was held that that's hearsay. But when we have a policeman, as in that Attorney General case in British Columbia, very recently reported in the Dominion Law Reports, that's different. That changes the ballgame because he is investigating pursuant to a statute. In other words, that which is ordinarily hearsay is then admissible because in that Attorney General case in British Columbia, as a matter of fact, he gave evidence as to their physical state, that they were sort of intoxicated at the time and inebriated and impaired and so on. So that does change the ballgame when the policeman is investigating. But I think with respect, that's on the civil side. On the criminal side, I'd have to go along with what the Eden case says. If he remains silent, the crucial test are really two things. Does the person adopt the statement? And secondly, is it the type of situation in which he should normally have remained silent? Is it denial or some statement called for? And if that's the situation, then it may well be said that he's adopted the statement that's being made.
Is there any difference if the person who made the statement in a criminal case happens to be an accomplice, and you could say, well, if, looking at all the facts, the accusation that was made is such that the accused would promptly say, you're a liar?
I think it would make a difference if it's an accomplice, because it goes to the whole issue of relevancy and the fact that they may be well associated in a particular transaction and so on. That changes it.
Now does it matter whether it's in a policeman's presence or not?
Yes, I think it does.
Still think it still does?
I think it makes a big difference because in the Tepper case, you have the exact opposite where that was held to be hearsay.
This case probably represents one half of a myth that really seems to persist. And the myth is that there is one vast universal rule that says that anytime any witness seeks to repeat the words of another, it's all hearsay, no matter what it's going to be about. But on the other hand, there is one vast, pervasive exception. As long as it's said in the presence of the other party, no matter what it was, it all goes in, which, as I say, which myth seems to persist.